Okay, we'll get started with panel number 3, International Commitments and Delegation. So first I want to start by thanking Jack and Kurt for organizing the law review, and particularly Jonathan Wiersema, who I'm still a little mad that he didn't go to Georgetown, but I've mostly forgiven him. But so I'm going to start by introducing our panelists, and then we will, sort of the system now. We'll go through and have each of the panelists talk for a while. So first, Kristen Eichensehr is a professor of law at the University of Virginia. She's the director of the UVA National Security Law Center. She writes about national security law, cybersecurity, foreign relations law, and international law. And she is a member of the State Department's Advisory Committee on International Law. Oona Hathaway is the Gerald C. and Bernice Latrobe Smith Professor of International Law at Yale Law School. She has served as a special counsel in the Department of Defense Office of the General Counsel. She's currently a reporter for the latest phase of the restatement of law of foreign relations, and is a member as well of the State Department's Advisory Committee on International Law. And Jean Galbraith is a professor of law here at the University of Pennsylvania Law School. She teaches and writes on international law and foreign relations law. She is an elected member of the American Law Institute, a member of the Board of Editors of the American Journal of International Law, and a longstanding member of the American Society of International Law. And finally, we have Shalev Roisman, who is an associate professor of law at the University of Arizona, James Rogers College of Law. He teaches administrative law, constitutional law, and on presidential power. He has served, one of the many here who has served as an attorney advisor in the State Department's Office of Legal Advisor. So welcome to all of you. The two papers we have, first Kristen and Oona will talk about their paper, Major Questions about International Agreements, and then Jean Galbraith will talk about her paper, The Organs of U.S. Foreign Affairs. And before we get started, I will give the first password, which is, international. Okay, I'll turn it over to Kristen and Oona.
Great, thank you so much. Thank you so much, Mary. Thanks to the organizers and to Kurt and Jack for putting this together. So I'm going to give an overview of kind of the first part of our paper, which if anyone wants to actually read it, it is posted on SSRN, so feel free to download it to get the fuller version. But we'll try to give an overview on the assumption that most people here haven't had a chance to read it. So our article considers how the rise of major questions doctrine and the revival of the non-delegation doctrine might put at risk the United States international commitment. So we're particularly focused on the application of these doctrines to international agreements. And international agreements in all of their various forms. So I'm going to speak a little bit about each of those. So I'm going to start by talking about the role of congressional delegations to the executive branch with respect to formation and implementation of various forms of international agreements. And then I'll briefly explain how the Supreme Court's recent decisions might spark challenges to the agreements themselves or to the authority to implement them, which we've talked a little bit about before. Then Kristen is going to take up where I leave off. She'll explain why delegations involving international agreements differ from purely domestically focused delegations in material ways that counsel against applying the major questions doctrine or non-delegation doctrines to them. And then she'll also speak to some of the steps that we propose in the paper for courts, for Congress, and for the executive branch to take to ensure that existing and future international agreements are well-founded in constitutional and statutory law. Okay, so that's the plan. So first, let me say a bit about international agreements and delegations. As been mentioned a couple times already today, the only form of an international agreement that's specifically provided for in the Constitution is so-called Article II treaties, treaties that are subject to advice and consent of 2/3 of the Senate. But in fact, these have been largely replaced, as John mentioned in his panel, by various forms of other kinds of agreements. There are very few Article II treaties being made on a regular basis now. And instead, most of the binding international agreements that are made by the United States are made through executive agreements. So there are various versions of these, or what we sometimes refer to as ex-ante congressional executive agreements that are authorized in advance by Congress. There are agreements authorized by a prior Article II treaty. And then there are sole executive agreements that are based purely on the president's own constitutional authority. And then there's also separately been a rise in what are sometimes called non-binding agreements. So these are agreements that purport not to actually create legal obligations, but nonetheless have very much the same form as executive agreements and create significant commitments, not binding legal commitments, but nonetheless significant international commitments for the United States. So I'm going to say a little bit about each of those. All these forms of international agreement making involve some delegation from Congress to the executive, whether as a basis for making the agreement or for domestic implementation. So I'm going to talk a little bit about each of those. So first, ex-ante, what we refer to as ex-ante congressional executive agreements. So these are agreements that exceed the president's own authority. The president can't make it by himself. He needs Congress to give him some authority in order to create this agreement. And this is often done through a statute that authorizes the president in advance to make the agreement. So Congress will enact a statute, and then that statute provides authority for the president to say, go out and negotiate fisheries agreements, say. So this is the basis for making the agreement in the first place is delegated by Congress. Now, in previous work that Kurt, Jack, and I did together that was published in the Harvard Law Review, I think 2 years ago, year and a half ago, 2 years ago, and the database is available online if anybody wants to download it. It's on Dataverse. You can pull this all up and look at it yourself. We looked at all the statutes that the executive branch relied on in these executive agreements. So we sued the State Department. We got over 5,000 cover memos. There are memos that go with these agreements from the State Department over to Congress, and they have this page that's not generally made publicly available that says what the legal basis for the agreement is. And then we pulled those and then had a huge group of research assistants go through and read these statutes and determine whether the statutes actually explicitly authorize the creation of an executive agreement or not. And we rated them sort of 1 to 5, with 1 being sort of, yes, this statute has some express authority to enter into an international agreement. To 5 is, no, it doesn't really say anything at all about executive agreements or even kind of imply an authority to enter into executive agreements. And then 2, 3, and 4 sort of various versions in between. And what we found is that 48% of the agreements from 1989 to 2016 relied on an authority to be coded 1, so an express authority. 34% relied on authorities that were 2, 3, or 4, so sort of various versions of like implied authority. And 19% basically relied on something, as far as we could tell, didn't have anything to do with an international agreement at all. So that means like fewer than half rely on a delegation that's expressed or particularly clear. And even then, this is being pretty generous to the executive branch, because all that we looked at was whether the statute that was cited had anywhere in it an authorization to enter into an international agreement. So often they would cite something like the Foreign Assistance Act of 1961, which is if you've read it, really, really long and covers a whole lot of things and has a few express authorizations to enter into international agreements, but they may or may not have anything to do with what they're cited for. So we were not able to sort of sit for every 5,000 and look to see, did that one actually get authorized by the Foreign Assistance Act of 1961. So this is a very generous number, 48% at best. Have kind of explicit express authorization. Okay, so that's executive agreements, ex-ante congressional executive agreements. Then executive agreements pursuant to treaty, similar idea. They're entered into pursuant to a prior treaty. There were over 100 unique international agreements that we found in this data set. And many of them only provide for subsequent agreements pretty obliquely. So, for instance, Article 1 of the Universal Postal Union Money Orders and Postal Travelers Checks Agreement, which was cited as an authority for a subsequent executive agreement, just provides that, quote, this agreement shall govern the exchange of postal money orders, hereinafter called money orders, and the postal travelers check service that contracting countries agree to set up in their reciprocal relations. Sort of seems to reference the idea that you've agreed to set up something in your reciprocal relations, but it doesn't seem to actually authorize the creation of an executive agreement necessarily. I think we would have coded that like a 2 or a 3. So, that it suggests that there's some kind of an agreement, but it's not expressly authorizing the creation of agreement. And then sole executive agreements and non-binding agreements, there you don't need the authority from Congress in order to create the agreement, but you often rely on the authority from Congress to implement the agreement. So to implement the sole executive agreement or the non-binding agreement, let me just take one example for the sake of time. Familiar non-binding agreement is a joint comprehensive plan of action, otherwise known as the Iran nuclear deal, which relies on extensive prior delegations of authority to the president in order to make and unmake various kinds of sanctions, as we talked about earlier. And so the president's relying on this prior delegated authority in order to carry out his side of the agreement, and that's where the delegation comes in. Okay, so let me say just briefly a little bit about where the challenges might come from. You may already, given the conversations we've had already today, be thinking, I can kind of see where these come in. It's probably pretty obvious. So first, agreements created using this implied delegated authority. So that's the ex-ante congressional executive agreements and the executive agreements based on a prior treaty. Here, in particular, the concern is that there would be a challenge where they're relying on an implied delegation rather than an express delegation. So I mentioned like 48% of these rely on what we coded a 1. So those are probably safe, although, depends on how close the relationship is between the actual agreement and the authorization. But let's say it's about 50% that rely on some form of implied authority. So those are at least potentially going to come under scrutiny. And the court's lack of clarity about what counts as a major question and demanding standard for congressional clarity about existence and scope of delegations can potentially leave a range of executive agreements vulnerable to challenge. Many of the statutes and treaties on which the authority rests are far from clear in their delegations. If you sit down and you read the statute and you read the agreement, it's all often quite difficult to kind of figure out how you draw the clear line between the two. And if a court was asked to look at that, there's a decent chance that they would at least call it into question. So if a court considers an issue to be a question of major political or economic significance, it's possible the court may require more particularized delegations than are often found in these authorities that are granted in advance for creating these agreements. In cases where authority is expressly granted in advance to conclude an executive agreement, it's entirely possible to imagine a court finding the text ambiguous, as it often is, frankly, kind of ambiguous. The court could potentially conclude that an agency possesses the authority to make international agreements, but a particular delegation is insufficiently clear to authorize a given agreement or set of agreements. Okay, so what about implementation? This sort of second bucket that I talked about before, agreements implemented using previously delegated authority. That is, sole executive agreements or non-binding agreements, you don't need delegated authority to make these, but you're going to often be relying on delegated authority to implement what you've promised to do under these agreements. So where they're going to run into difficulty again is on this implementation. One could imagine a challenge to an agreement where the delegated authorities the president seeks to use to implement an agreement involve questions that are too major and in which Congress has not been sufficiently clear in its delegation. While such a challenge would not prevent the conclusion of the agreement, the president can still make the agreements, it could render the executive incapable of actually carrying out its obligations under the agreement. In case of sole executive agreements, that would be binding obligations. In the case of non-bindings, it may be non-binding, but still nonetheless often reciprocal. You're sort of relying on the other side to do what they say they're going to do. And if you don't do what you say you're going to do, they're going to stop doing what they said they're going to do, right? So that there are implications that come from that, even though it's a so-called non-binding. So were that to happen, it could damage the reputation of the United States, frustrate the purpose of the agreement, and even place the U.S. potentially at breach of its obligations under international law, thus potentially even subjecting the United States to countermeasures as a result. And as we were talking about this, we realized one of the particular problems here is that even a single challenge to the capacity of a president to implement a sole executive agreement or non-binding agreement using pre-existing delegated authority could really upend U.S. international diplomacy because it could call into question the whole range of these. As soon as the idea that the president's capacity to use prior delegated authority to implement these agreements is called into doubt, it calls into doubt not necessarily just that single agreement that is being challenged, but a range of agreements that are relying on this. I'll say just briefly, similar problems with the reinvigorated non-delegation doctrine. So agreements created based on implied delegation. Again, you might see the court potentially decide that the court's delegated too much authority to the executive and thus divested itself, and in particular the Senate, which we can remember in the Constitution is the only one that has the power to give advice and consent to a treaty of its constitutional role. There's some modest reason for comfort in Gorsuch's opinion in Gundy, which seems to have a carve-out into which these might fit, and Kristen's going to say more about that. But nonetheless, it's far from clear exactly what Gorsuch meant in his description of the kind of potential carve-out and whether, in fact, necessarily this will fit. It's possible they could decide even express delegations of Congress to the executive branch could violate the non-delegation doctrine because they take the Senate out of the process entirely. And so that's I think, a potential concern. And then last, agreements implemented using previously delegated authority, that is the sole executive agreements and non-bindings, while the agreements themselves can't commit the United States to actions that exceed the president's own authority. The president, as I said before, relies on delegated authority to carry out those agreements, and that could be a challenge as an improper use of delegated authority to evade constitutional requirements of Article 2. So those are the concerns that we put forward, and now Kristen's going to solve all those problems.
A small lift. So we argue that there are a number of distinctive features about international agreements and the delegations related to them that make it particularly problematic to use the major questions doctrine or the non-delegation doctrine to disrupt them. So I'll highlight 4 of them. First and most basically, international agreements involve negotiations with another state, whereas domestic delegations do not. So Congress simply can't delegate with the same level of specificity with respect to international agreements that it does with respect to, or that it could at least with respect to domestic delegations, because the executive branch has to negotiate with another sovereign state that has its own interests, it has its own negotiating positions, many of which may not be known in advance. So requiring high levels of specificity in congressional delegations and congressional authorizations to negotiate international agreements risks chilling the executive's ability to negotiate these agreements at all. And then there's the risk of imposing the new major questions doctrine or non-delegation doctrine retrospectively on agreements that have already been concluded. This risks upsetting bargains based on this new view about what constitutes an overly broad or an unspecific delegation. And that brings me to the second point, which is that using the non-delegation doctrine or the major questions doctrine to invalidate international agreements or legislation that's used to implement those agreements could have serious negative international repercussions for the United States. And Oona's already touched on this a little bit. But these repercussions could be both legal and political. So imagine that you have a court that declares an international agreement invalid based on either the major questions doctrine or the non-delegation doctrine, or that invalidates domestic statutory authority that the president has used to implement an international agreement. That doesn't terminate the international agreement internationally. So the president at this point faces a few rather unattractive options. So the president could decline to terminate the agreement internationally, which I'm sure would be rather displeasing to the domestic court. But he would do that, even if he did that, he would risk allegations that the United States is violating international law by failing to implement the international agreement. Or the president could, on the international plane, terminate the international agreement, acting in compliance with the domestic court. But that doesn't end the legal risk. So one problem with that is timing, right? So many international agreements have a waiting period before termination or withdrawal can become effective. And for ones that don't, but evidence the party's intent to allow withdrawal or termination, the Vienna Convention on the Law of Treaties specifies that parties have to give 12 months notice before they can terminate or withdraw. So would a U.S. court stay its judgment for a period of time, stay its ruling for a period of time to allow the president to comply with the timing requirements internationally? Seems unlikely. Another international law problem could come from the reasons for termination or withdrawal. So there are some international agreements that do allow parties to withdraw for basically any reason after the appropriate notice period. But not all agreements permit this kind of reason-free exit. And so for those agreements, the Vienna Convention on the Law of Treaties, again, specifies a number of permissible grounds that would justify treaty termination or withdrawal. These include breach by a treaty party, impossibility of performance, fundamental change of circumstances. Not on this list is a domestic court ruling that the agreement is invalid on the basis of internal law or determining that the domestic authorities used to implement the agreement are invalid. So even apart from these legal consequences, that's the sort of legal risk the United States would face. There's also the political risk, which Oona already mentioned. So having the United States be forced to withdraw from international agreements because of a domestic court decision would upset foreign partners. It could decrease the perceived reliability of the United States as an international agreement party going forward. And we think these sort of political risks are all the more acute when you have the executive branch and Congress, the parties who are involved in making international agreements, perhaps being forced into this by the courts. All right, so those are the first two reasons we think major questions and non-delegation should not be used to upset international agreements. The third reason is that failing to distinguish foreign relations-related delegations, including the agreement-related delegations that we're focused on, runs counter to substantial historical gloss from Congress, and well, from the Supreme Court, really, and from the practice of the branches over a long period of time. So the Supreme Court has, for a long time, treated foreign relations-related delegations differently from domestic delegations. This came up quite a bit on the first panel in the discussion today. So this was really crystallized in Curtis Wright, where Justice Sutherland pointed to what he called the unwisdom of requiring Congress to lay down narrowly definite standards by which the president is to be governed in foreign relations. And this has continued through many cases since Curtis Wright as well. So historical gloss counts as in favor of carving out international agreements. And then fourth and finally, the Supreme Court has a history of not fully appreciating the disruptive effects of its decisions on foreign relations. And it's this past history we think should give the court pause before it further exacerbates the past court-caused disruptions. So what we have our eye on here is CHATA. CHATA invalidated legislative veto provisions, and this affected some well-known foreign relations statutes like the War Powers Resolution, but it also affected statutes related to international agreements. So Congress couldn't revisit every law that delegated agreement-making authority conditioned on Congress's retaining legislative veto about the agreement, whether the agreement would go into effect. So what Congress did instead was to go back and strip out the legislative vetoes, leaving the largely unconstrained delegations in place. So this had the effect, actually, of expanding presidential discretion and control. And this isn't perhaps what the court intended or foresaw. So we argue that this history should give the court pause before it again intervenes in the delegation of powers from Congress to the president in foreign affairs. Those are all the reasons we think that major questions in non-delegation as applies to international agreements are a bad idea. So what do you do? We offer suggestions for all three branches. So I'll start with the courts, which is, I think, our most extensive recommendations are for judges. So for judges who are concerned about congressional delegations regarding international agreements, or at least concerned about following the Supreme Court's lead about these sorts of things, the most straightforward approach is to carve out international agreements from the general major questions doctrine and the non-delegation doctrine. Doing so would be, as we say in the paper, consistent with foreign affairs exceptionalism and with historical gloss from the Supreme Court, as well as with Curtin Jack's focus on independent presidential powers. So we are writing for judges who are looking for a way to square the major questions doctrine and the non-delegation doctrine as they are currently evolving with concern about disrupting international agreements. So I think all of these theories, and I'm happy to talk more about this in Q&A, but we think we end up in largely the same place. And I think we're also sort of pushing on an open door here. So as was already discussed in the first panel, even Justice Gorsuch, who has emerged as the court's biggest proponent of the non-delegation doctrine, seems willing to do something along these lines. So in his dissent in Gundy, Justice Gorsuch identified several areas where broad delegations would remain permissible, even with a reinvigorated non-delegation doctrine. And we think two of those are particularly relevant for international agreements. So first, he noted areas where Congress's legislative authority overlaps with authority the Constitution separately vests in another branch, citing Curtis Wright and Youngstown, and specifically noting that many foreign affairs powers are constitutionally vested in the president under Article 2. So that's his first exception, or to use Curtin Jack's parlance, qualification. The second is where he identifies instances where the exercise of the delegated authority depends on executive fact-finding. And he gave yet another foreign relations-related example to illustrate that exception. So taken together, we think that these two exceptions would cover most, if not all, delegations involving international agreements. So international agreements necessarily involve foreign relations, and at least at the negotiation stage, they involve communications with foreign governments. These are areas of presidential power. So some international agreements, like commercial agreements, will obviously fall within areas that are shared areas of congressional and presidential power. And for sole executive agreements and non-binding agreements that the president has the authority to conclude alone, executive reliance on delegated authorities for implementation suggests that they too could fall within this idea of areas of shared constitutional authority. So in addition, many authorizations of authority to conclude congressional executive agreements could fall under Gorsuch's second exception, the one for being based on executive, either explicitly or implicitly relying on executive branch fact-finding. So we give an example of one of the earliest statutes that expressly delegated significant authority to the president to conclude congressional executive agreements. This is the McKinley Tariff Act of 1890, which provided that sugar, molasses, and some other items would be on the free list, so they wouldn't be subject to a duty, unless the president determined that the exporting country had imposed unjust and unreasonable duties on American products. So that provision was understood to authorize the president to conclude reciprocal free trade agreements with other countries, and many such agreements followed. But it depended on executive fact-finding about what the exporting countries were up to. So Gorsuch's opinion, as was discussed earlier today, in Gundy, is overtly about the non-delegation doctrine, where he lays out these exceptions, not the major question doctrine. But we think the same logic should be basically read over and cross-apply to the major questions doctrine. As Marty said on the first panel, that's where the action seems to be right now. In the doctrines, the major question doctrine's foundational interpretive presumption that Congress doesn't intend to or wouldn't wish to delegate substantial authority and discretion to the executive branch, especially does not hold with respect to statutory delegations relating to international agreements. Congress has a long history there of delegating broadly on those agreements. And to the extent that you take solace in Justice Barrett's concurrence in the student loan case, Congress's history of broad delegations could also be considered an important contextual factor. We are aware, of course, of the critiques that have been raised about foreign affairs exceptionalism over the years. Some of those concerns we share. And I think one of the strongest concerns is the one that came up earlier today about basically the boundary drawing problem. So what counts as foreign affairs? What's foreign? What's domestic? Our approach, what we call international agreements exceptionalism, avoids that big problem, big challenge to the broader foreign affairs exceptionalism idea. It will be clear to courts that there is an international agreement at issue with all the international ramifications that entails. So let me say a quick final note on this, on implementing legislation before turning to Congress and the executive. So we think that the arguments for a carve-out or a qualification along the lines of international agreements exceptionalism are strongest with respect to invalidation of the international agreements themselves. But we also argue for extending international agreements exceptionalism to encompass domestic statutes that are used to implement international agreements. This is largely for functionalist reasons. So the failure to implement binding international agreements poses similar risks from international law, from international politics perspective, as terminating or violating agreements. And extending exceptionalism to implementing legislation is more complicated, and we acknowledge that in the paper. So the domestic law used to implement international agreements may many times quite obviously be implementing an international agreement. The complication comes when it's not so obvious. So when the domestic statute does not otherwise appear to involve international law or foreign relations, that our approach of international agreements exceptionalism would create the possibility that a statute might benefit from that exceptionalism if it's considered in a case involving an international agreement, and not benefit from the exceptionalism, be subject to major questions doctrine, et cetera, in other cases. We think those cases will be fairly rare. But where they do arise, we argue that judges should at the very least consider the international ramifications of invalidating the authorities necessary to the implementation of international agreements. The court's current, although still evolving with every case, view of the major questions doctrine is that it is a multi-factor test. And the international implications of invalidation, we think, should be at least one factor considered in that multi-factor test. Or if you take Justice Barrett's approach from Biden v. Nebraska, the international ramifications could very well fit in as part of the context for interpreting related delegations. And considering them would be, to use another one of her phrases, it would be common sense in our perspective, in light of Congress's long history of painting with a broader brush in international as opposed to purely domestic delegations. Okay, let me wrap up with just a brief word about what we say with respect to Congress and the executive. We have thoughts for them as well. So much of the paper is obviously a defense of existing delegations, existing international agreements based on them. But at the same time, we do urge Congress to be clearer and more specific going forward. So Congress, we think, could do a better job, and it would behoove Congress to do a better job going forward of clarifying its intent to delegate authority to the executive to conclude international agreements, and maybe providing somewhat greater specificity about what those agreements should entail. The new transparency and reporting provisions that were enacted as part of last year's NDAA will help Congress with this goal going forward. So the State Department's reporting on the legal authorities that are being used for international agreements and non-binding agreements should give Congress somewhat better insight into how delegated authority is actually being used. And then for the executive, our caution here is really for the executive to understand that its international agreement making is likely to be subjected to greater scrutiny. The congressional reporting provisions have ensured that that is already the case, but the executive should understand going forward that its prior practices may be subject to challenge under the major questions doctrine or the non-delegation doctrine. So going forward, the executive branch lawyers should work more closely with the relevant congressional committees to ensure that the agency's actions, that the agreements they're negotiating are resting on solid legal foundations. We think that doing so is actually in the best interest of both Congress and the executive to make sure that their work in creating and implementing international agreements is insulated from possible disruption by the courts. So I'll stop there and just say thank you very much to the editors of the Law Review, particularly to Jonathan, to Kurt, and to Jack for convening this symposium, to Mary for moderating, and Shalev, we look forward to your comments.
Well, thank you. And let me first echo the thanks to Kurt and Jack and the Law Review and Ecclesiastes and Jonathan. Jonathan, everyone except Mary would be mad at you if you had gone to Georgetown here, so I think you're just fine. It's a real joy to be at a symposium on foreign relations law here at Penn that I had to do nothing at all to help organize. And to the students here, let me say that if you are enjoying the topics here or you want to read the Medellin decision in all its ignominy, or you want to be more confident in the devastating critiques that you're going to give all of us on our draft papers in the spring, well, I'm teaching foreign relations law in the spring, and I hope to see you all in it. All right. So the project I'm working on, as Mary mentioned, is called The Organs of U.S. Foreign Relations Law. And just to situate this briefly in what we've been talking about here so far, one of the threads of conversation which my project is not engaged with is this question of how we should understand congressional delegations of power to the president, whether there's a non-delegation doctrine that's applicable in the foreign affairs context, and even if not, or even if so, how we interpret those statutes. Another question that's been bound up in that you've heard a bit about has to do with the independent powers of the president in foreign affairs. And the third piece, which my project here really focuses on, and which has been foreshadowed a bit by things that Tim and Kathleen said, and Andrew and some of the others a bit at lunch as well, is really where does the president have an exclusive domain of foreign affairs powers such that Congress cannot intrude? And it turns out that fairly frequently, the president or executive branch lawyers in some capacity will say that they can ignore certain pieces of congressional legislation for this reason. And that's especially true in what you might broadly define as the context of diplomacy, where the United States is sort of presenting itself outward to the world. And when they say this, the executive branch lawyers or the president, they usually invoke a particular phrase. And this phrase is, "The president is the sole organ of the nation in its external relations." And then they basically say, so go away, Congress. So for example, when President Reagan in the late 1980s signs a big omnibus bill that has in it a lot of conditions on how he's supposed to carry out some negotiations, he says in his signing statement, well, I am the sole organ of the federal government in the field of international relations, and so therefore I have exclusive authority to determine the time, scope, and objectives of any international negotiations. More recently, during the Trump administration, there's a pretty small bill that's focused on 5G technology and making it more secure domestically and internationally, and this gives the president certain authority to do certain things. But it says, look, if you're going to do something that would otherwise have already been in the domain of the FCC, the Federal Communications Commission, then they need to sign off on it. Seems totally reasonable. In his signing statement, President Trump says, well, I am the sole organ of the United States in its foreign relations, and so I feel empowered if I want to disregard that condition. Now, this phrase, the sole organ phrase, it didn't come out of thin air. I think the right way to think about it, and I'm a reader of fantasy novels, is really to kind of think of it as a zombie in foreign relations law. It keeps getting killed, and it keeps coming back. And so what I'm going to do here is is to tell you a bit about where this phrase comes from. I'm not going to try to kill it because I think it's unkillable. But I am going to try to, I think, maybe raise some more zombies that can help us to think a bit about what it means. So first, where does this phrase, the president is the sole organ of the nation in its external affairs, where does it come from? So it comes originally from a speech given by John Marshall before he was a Supreme Court justice, even before he was Secretary of State, when he was a member of the House of Representatives. And he used this phrase in a speech in 1800, defending the president's power to implement an extradition treaty. And Nick earlier said, well, let me read a little more into what you said, but more or less implied, wouldn't it be crazy if we looked at what a congressman said in the House of Representatives in 1808 and took that really seriously if it was just one guy saying it? And the interesting thing about this John Marshall remark is that it really has become a kind of iconic thing in U.S. foreign relations law, even though it's not in the Constitution, and even though it was almost largely dormant until that Curtis Wright decision that Kristen and Oona have mentioned and Kurt mentioned earlier in the 1930s, when Justice Sutherland, in his opinion for the court, draws on this sole organ language, quotes that phrase that I read above in dicta, that sounds very favorable to both the president's independent powers over foreign affairs and the idea of some exclusive presidential power over foreign affairs. And once this phrase comes to life, is resurrected at this moment, at that point it becomes a frequent citation, particularly for executive branch lawyers, when they want to say there's exclusive presidential power. And our colleague Harold Coe has put it that executive branch lawyers will say, Curtis Wright, so we're right. And they're really sort of channeling that sole organ concept. Now, in its 2015 decision, in the Zivotofsky case, the Supreme Court held that the president does have the exclusive power to recognize foreign nations, and that Congress can't interfere with this power. But at the same time, the court went out of its way to really throw cold water over this phrase, the president is the sole organ of the nation in its external relations, to say that that phrase was dicta, that we have never recognized this unbounded power. Yet, even after Zivotofsky, at least in the Trump administration, you see lawyers continuing to use this sole organ phrase, as I gave one example, and there are many, many more from that. And you also see that some lower courts are continuing to use it as well. So the paper I'm working on, it really comes out of a kind of light bulb moment, which I'll tell you about. Somebody asked me about this before the conference started. And this is when I was reading, more or less for fun, a 19th century treatise on international law in the federal government. And I came across a section of the treatise, a whole section, and it was called Foreign Ministers to Recognize the Secretary of State as the Sole Organ of the Executive. And reading this really made me blink, because anytime I see the word sole organ, I think immediately of the president, and I'd never seen this phrase attached to the Secretary of State. So this caused me to sort of go on. I don't think that this is historical work so much as really kind of like doctrinal etymology almost, on a kind of like tracking how the word and the concept of organ has been used in the late 18th and the 19th century in the kind of public governance context, and particularly in the realm of foreign affairs. And the phrase sole organ comes up occasionally in various contexts, not too often. More what you'll see is just the organ, or maybe the constitutional organ, or the legitimate organ, or sometimes the only organ, or sometimes in a really like hesitant way, and this is actually also now Chief Justice Marshall, the mere organ, that's in Marbury, talking about the Secretary of State. So what do I find when I just sort of dug through and looked at this? And the first thing I will say is there are a lot of references in this period to the president as the organ of the United States in foreign affairs. Now, most of these are referring more specifically to the president as the organ who's representing the United States abroad or who's communicating with foreign powers. But I was also struck that there were a lot, and I think actually maybe even more than to the president, of references to the Secretary of State as the organ for dealing with foreign nations or for communicating with them. And I think at least some of this stems from a background assumption from the law of nations at the time that sort of channels the idea that certain kinds of communications are to go through foreign ministers before the French Revolution really sort of shakes that up pretty dramatically. And it's notable that some of these references are in situations where ambassadors from other nations are trying to bypass the Secretary of State and deal with the president directly. So Jefferson, for example, uses the word organ when he's telling the wayward ambassador from France that the Secretary of State is the organ through which your communications should pass. And most of the time, the president, these uses with the Secretary of State are describing the Secretary of State as the organ for the president. There is one or two which are a little different, such as one where Jefferson describes himself as Secretary of State as the organ of Congress. Other uses of organ, the Supreme Court, as I said, it doesn't use that Marshall phrase in a majority opinion in the 19th century. That phrase is used in a dissent. But there are several cases that talk about the Secretary of War as the regular constitutional organ of the president for the administration of the military establishment of the nation, or sometimes as the legitimate organ for the president. And there are lots of other uses of this word organ as well, both in the foreign affairs context and in other government settings. So justices actually not infrequently describe themselves as the organ of the court when they're issuing the majority opinion. And in Congress, the chairs of the Foreign Relations Committee will sometimes describe themselves as the organs for these committees. Now, what do we want to make of all this? Well, let me say candidly, I'm not sure yet. I'm really in a kind of preliminary stage in my research and in my thinking through this. I don't think this sole organ language should ever have gone up on a pedestal, and there have been a lot of scholars who have made that point. And I'm hopeful that my sort of excursion here can help out a bit with that. So let me spell out the two things I'm thinking about in terms of implications of this research. So the first is this one big question about what Marshall's original use of the sole organ was, is whether it was meant to describe an exclusive presidential power as the mouthpiece of the government in foreign affairs, the mouthpiece, or whether it was about an exclusive presidential role as the actor who gets to make the substantive decisions about foreign affairs, not just to communicate them, but to really decide what's being communicated. And that's the way that Reagan uses the phrase in that signing statement that I mentioned, for example, when he says he gets exclusive control over the time, scope, and objectives of international relations. Now, I think the usages that I find point actually quite strongly to the idea that this word organ used in this area, the dominant meaning is as a mouthpiece, as the agent whose job it is to be the spokesperson. But not the person who gets to have necessarily the final and complete say over what is being communicated. We don't think, for example, that when they say the Secretary of State is the organ for the President in foreign affairs, that can mean that the Secretary of State gets full power to decide what is being said. That makes almost no sense. To the contrary, we think of the Secretary of State as being the agent of the President. I don't think this means that the organ has no control over the content or no right to generate independent content, but rather I think of this control as more the power to make a day-to-day decision where the principal has been silent. So I think that these other usages suggest that Marshall's usage of the sole organ language was likely to refer to the president as a mouthpiece. And I should say that conclusion really does line up with how most scholars who've looked at the Marshall speech specifically have read it, even without the benefit of this other sort of information about organs. Now, the second implication, which I'm really thinking through, relates to a kind of different concept of exclusive presidential power. So the sole organ language today is sometimes used by presidents, and you see this in particular by the Trump administration, to support a kind of robust theory of the unitary executive in the foreign affairs contexts. Now, while most discussion of the unitary executive in the Supreme Court is really focused on the question of the extent to which Congress can place limits on the president's power to remove officials, there's a strand of this theory that's also used to argue that the president, rather than Congress, should really get to decide which executive branch officials carry out what duties, generally and with a sort of strong story in relation to foreign affairs. And the signing statement that I mentioned earlier from the Trump administration is really, I think, channeling that idea of the sole organ as a strength for the unitary executive theory. So as I look back at these other usages of organ, with respect to the Secretary of the State and the Secretary of War, I think they're offering a kind of vision of the infrastructure of the executive branch that goes beyond the control of a single president, and perhaps ways that are not even reflecting just statutory organization, but are even quasi-constitutional or baked somehow into the idea of public law and governance. Now, I have more to do to look into this and explore what it means, but it suggests a kind of vision of the administration in the foreign affairs context that can be viewed as disaggregated from the president. So I will stop there and pass it down the line.
Thank you, and thank you to the organizers for including me. I'm very honored to be on this panel with my co-panelists here. And I think one kind of beauty of events like this is that as we go throughout the day, we can kind of build on the conversations from earlier, and I'm going to do that a little bit in my comments and echo some of the comments that have been made about some of the work we've talked about today. So I thought I would first talk about Oona and Kristen's paper on the major questions doctrine. And I should say that I very much agree with the thrust of the paper, which is that that it would be bad to apply the major questions doctrine to the realm of international agreements. But I found myself agreeing mostly because I think it's bad to apply the major questions doctrine to the domestic arena as well. And so my first question is one which I know you anticipate, but it's whether the reasons to not apply the major questions doctrine internationally are really meaningfully different from the reasons that we ought not apply it domestically, or to put it kind of in reverse. If we accept the doctrinal premises of the major questions doctrine domestically, is there a good reason not to apply it to international agreements? And so a few of the reasons that the paper gives struck me as at least comparable. So first, international agreements involve negotiations with foreign states that are, quote, often time-consuming, intensive, and detail a range of trade-offs and compromises from each side. So it's true that the partners are foreign states in the international agreements realm, and that's not true domestically. But the rest of it strikes me as true domestically. So when you're issuing a regulation, you publish the notice of proposed rulemaking, you take comments, that involves time-consuming, intensive trade-offs. You have partners domestically who you are negotiating with often. And if you undermine that deal about, say, what is the best system of emissions reductions, as was the case in West Virginia versus EPA, you're going to basically renege on a promise you've made to a bunch of people, to the American public in some ways. And I wasn't quite sure why we ought to kind of care more about reneging on a deal with international partners than we care about reneging on a deal with domestic partners. You might actually think it should be the reverse. Okay, second on the idea that Congress cannot delegate with the same level of specificity with regard to international agreements for domestic delegations. And for that, I wasn't entirely sure if I agreed with it. I don't think I categorically agree with it. I'm sure it's true in some areas and not others. But as a kind of grand justification, I take that notion to be the reason we have an administrative state, is that there's basically been a realization that Congress cannot delegate with the level of specificity that we might prefer because the modern society and economy is so complex. So we can't trust Congress to figure out how many parts per million of a pollutant to put in the environment, whether there's a safe level of benzene in the workplace, whether we should have seatbelts or airbags or just airbags or airbags and seatbelts, whether what amount of decibel levels a worker should be exposed to for 8 hours. And so these are the sorts of things that I think are, to me, kind of the raison d'etre of the administrative state, was that we kind of came to the realization that Congress is not up to the task of regulating in a way that we think the economy or the society should be regulated today. Third, on historical gloss, so of course it's correct that there's a long history of deferring to foreign affairs delegations by the courts, but again, there's a long history of deferring domestically as well. That's why, as Cass Sunstein said, the non-delegation doctrine had one good year and 70 bad ones are now 90 and counting. So now, it's kind of seems to be some pushback now, but before there was pushback, there was also this historical gloss. So I think we might need another reason other than just the fact that the courts had a certain practice that they ought not go back on it. I feel that I've been a little bit critical. So one more constructive comment on this front is, it did occur to me that the premise of the major questions doctrine is that it kicks in once there is a major question. And basically the reason I think I'm against the doctrine is because I don't know what that means. I don't think anyone knows what that means. But if you believe that courts can identify what a major question is, which the majority of the court obviously believes they can, I could see an argument that the court is better positioned to identify major questions domestically than internationally because they just are more tuned in to domestic affairs than they are internationally. And so maybe that would be a reason that we ought not allow courts to apply it internationally because they're just not going to know what is an issue of major economic or political significance internationally, even if they do know what it is domestically. I'm not sure I buy that, but I might buy it. So the constructive way to put all that, and I hope it didn't come off as too critical, is just it might help to kind of acknowledge these similarities a bit more in the paper and face them more directly. My second main comment is about whether it might also help to talk a little bit more about institutional competence. So some of the bad outcomes of applying the major questions doctrine that the paper points out, which are, I think, again, I agree with, are that it could create embarrassment on the international stage if we sign an agreement and basically the court forces us to get out of it, and it could require the United States to violate international law, and both of those things are bad, in my view. But they are both things that the president and Congress can do, and we all accept they can do. So Congress and the president embarrass us on the international stage, many times. They join the JCPOA, they get out. They join the Paris Agreement, they get out. They get back in. The House of Representatives just exists. And so I think, and of course Congress we all know, can violate international law. And so I think what might help in that part of the paper, and this is in line with some of Judge Wood's comments, would be to just talk about why we're okay with the political branches embarrassing us on the on the international stage. We're okay with the political branches violating international law, but there's a good reason that we don't want the court to be the one forcing us to do that. And I think that's an argument that really could be made and would help strengthen that piece of the bad consequences and make it unique to the international sphere. Okay, my last comment relates to the first and relates to something that Marty Lederman mentioned in the first panel. So, as I said, I'm a little bit unsure that if we accept the doctrine, there's good doctrinal reasons not to apply it internationally, but I do see strong political reasons not to apply it internationally. And by that I mean, when I look at the current Supreme Court, I see the kind of what I would call like the conservative synthesis of the majority is a desire. I don't know if it's conscious or subconscious, but the outcomes seem to me to suggest a desire to limit the size of the domestic regulatory state, but permit broad, expansive executive power in national security and foreign affairs. And I would say the progressive synthesis, at least among the academy, is the opposite, which is real comfort with a broad domestic regulatory state and a skepticism and fear of broad executive power in national security and foreign affairs. And I see your paper is really fitting in the conservative synthesis bucket, and which is fine, of course. But I get the sense in the introduction that you're skeptical of the major questions doctrine domestically, right? And so I just wondered how you think about this, the alternative strategy, which again, Marty alluded to and Kurt kind of talked about not pursuing, but it's something I think is worth at least thinking about, which is, well, what do we do if we force the court to take the bitter with the sweet, to basically say if you're going to apply it domestically, well, then apply it to the area you don't want to apply it to, and the result of that could be that they limit its application even domestically. I think I agree with everyone who spoke this morning that I don't really see that happening, but that's really a political judgment. And I don't know if I'm right or wrong or what, but I just think that sort of strategic question is one that if you have reactions to, I'd love to hear them. Okay, on Jean's paper, so I just love this project. It's like so fun. We've all looked at, well, maybe not everyone in this room, but we've all looked at this phrase, sole organ, and seen it, and I had just never, focused on the word. I mean, I've never thought about the word organ ever in my life so much as when I read this paper. But it was just such a fun sort of project to think, well, where was this used? How is it used? What does it really mean? And I think I find very convincing the overall thrust, which is to undermine the sort of exclusive powers, broad, expansive reading of the statement. So I had a few, maybe 3 or 4 overarching comments about this project as well. So just to start, the Marshall quote is, "The president is the sole organ of the nation in its external relations and its sole representative with foreign nations." And I guess I wanted at the outset, and I'm sure others have said this, but I just wanted some acknowledgement like that's clearly wrong, that it is just not true that the president is the sole organ of the nation, and whatever that word means. Congress has the power to regulate foreign commerce, which obviously involves external relations. Congress has the power to declare war, which is a representation to foreign nations. Congress has the power to define and punish the law of nations. All of these involve external relations, and so just that phrase to me has always just seemed clearly overstated. And that makes sense of Madison's statement about the Neutrality Proclamation, of the court statement, and how do you say it? Bass versus Ting? Who wants to say that out loud? Okay, Bass versus Tingy? Okay. So what they're saying is, of course, Congress has a role as the organ in the war space, which means that Justice Marshall was wrong, I think, if you take literally what he's saying. So I guess I wonder if you've thought about kind of framing that or acknowledging that even more strongly, but I understand why you wouldn't want to. Okay, so then on some of the other implications that you talked about, first on the control over content. So on the idea that the Secretary of State is the organ of the president, which suggests that the Secretary of State does not have full control over the content of the communication because, of course, the president can override the Secretary of State. So I get that. That makes sense. And so then the analogy is that if the president is the organ of the United States, then the president does not have sole control over the content because the United States is really the principal and the president is the agent. I think, though, there's a little bit of a disanalogy because we know who speaks for the president. It's the president. And so in the Secretary of State president relationship, we do know that the president can override what the Secretary of State says. But for the president to be the agent of the United States, the whole question is who speaks for the United States. And so I just wasn't quite sure that it really because you could still just say that, well, the president is still the only speaker for the United States. That's the question. And so the fact that we know that the president speaks and can override the Secretary of State doesn't really tell us anything about who speaks for the United States, or at least that's one way to read it. Okay. And then on the unitary executive point, here too, so the basic idea is that there are these allusions to the president using the Secretary of State or the Secretary of War as the president's legitimate or regular constitutional organ, and that suggests perhaps that the president is not fully in control of the agents that the president uses, which is inconsistent or in tension with the basic unitary executive theory that the president is has full and exclusive control over the executive branch. And here I wondered if the allusions, at least to me, and I haven't looked at them as closely as you have, obviously, did not strike me as so I think it almost buys into the exclusive powers mindset that I see the paper as kind of opposing, to see those allusions as suggesting that the president can only use the Secretary of State or can only use the Secretary of War for these matters. And on the Secretary of War one in particular, it says that the Secretary of War is the regular constitutional organ. I really have never said organ so many times, but that to me again seems like that's an option for the president, but didn't strike me as like the only option. Or at least that's not how I read it. Okay. And one thing that occurred to me as you were talking was that on the mouthpiece point. So I take the piece to basically accept the idea that sole organ means the representation function or the messenger function. And I wonder if that makes the statement kind of redundant. So if organ really means representative, and maybe we could have a debate about what representative means, but then it would just say the president is the sole representative of the nation in its external relations and its sole representative. So if that's all it meant, then maybe it would be redundant. So maybe it must mean more than that, or maybe, again, he was just overclaiming. Okay. And then the last point is how I should have started, which is a methodological question. And you alluded to this a bit in your remarks. And I guess I was just wondering kind of what is the meaning we're trying to figure out? So it's not an original public meaning paper, right? You're not asking what an ordinary person would have meant using the term organ. The paper is focused on how other elites of this era in the 19th century used the terminology of being an organ. And I just wondered a bit about how you kind of made the choice to focus not on ordinary people and focus on elites, and to focus only on the 19th century rather than just 1800, or rather than the 19th century and the 20th century, and just kind of what is it that what meaning are we trying to find through the exploration of its use by elites and lawyers and judges over this time period. So with that, I've probably gone on too long, but thanks again for having me comment on this terrific set of papers.
Great, thank you. I think I'd like to start the conversation by having you respond to Shalev's comment, and if you're going to start Kristen and Oona with his first comment, I sort of want to piggyback a little on it, because and that is about why can't these same arguments be made for domestic. I had a sort of narrower reaction when I was reading it is, are you, by narrowing it to international agreements, are you maybe undermining the broader foreign policy delegations, arguments for broader foreign policy delegations? So maybe I can add that to his first point.
Great, I'll take a first cut at it, but I'm going to leave lots unanswered that Kristen will play cleanup or fix the mistakes in the answers that I've given you. So on the first question, I maybe partially to start with what you just said, Mary. I think we're not, at least we're not defending in this paper, and in fact we're critical in this paper of an idea of like a broad foreign affairs exceptionalism. I myself very skeptical of that. I don't want to speak for both of us, but I'm skeptical of it for many reasons that have been said here. I think that often the courts treat foreign affairs as this kind of distinctive area where they suddenly lose all the powers that they have when they're working in the domestic arena. Suddenly they can't read statutes in the same way that they read the exact same statute. The AUMF they can read when it's about delegation, but when it comes to war powers, all of a sudden they lose their capacity to read a statute and interpret it. And I don't understand that. I'm myself critical of this idea that somehow there should be this broad exception, but I do think there's something distinctive about international agreements, and that's why we're really focused on international agreements. And I do think this is partially the answer to your point, Shalev, which is it's not just like in the domestic context where you maybe, yes, you're right. I think it's a fair point. You're negotiating things maybe with, state actors or like non-private groups or, internally within the federal government. But I do think there's something distinctive when you're talking about working with an independent sovereign state with whom you are engaging as, the United States, engaging in negotiations, coming to an agreement, and then putting the word of the United States behind that agreement. And then, on top of that, if you're talking about a binding agreement that you're failing to live up to, there's potential countermeasures against the United States. So say we fail to implement an agreement that's a binding agreement, and therefore we're now out of compliance with the agreement, that creates a possibility of there being countermeasures put against the United States, which could be harmful in a whole host of ways. That are distinctive. You're not going to see something like that on the domestic arena. But I think your points are fair. And I will say, again, speaking just for myself, but I suspect Kristen agrees with me. I'm not a fan of the non-delegation doctrine, generally speaking, or the major questions doctrine. So, I think you're right that some of these problems are absolutely true in the domestic sphere as well. And it's why I think, in general, this is a bad development in the courts, but is really, really, really bad here for the reasons that we're trying to describe. Just one last point from me. On the institutional competence point, you say, the Congress and the president can screw things up, so why not the courts? Fair enough. But I guess what I worry about here is that the potential ramifications of of calling into doubt even a single agreement in these ways could have kind of catastrophic effects for hundreds of agreements, both past and present and future. So I think once you call into question whether the federal government's going to be able to live up to the promises that it's made, because the court can call into doubt whether these doctrines allow it to actually do what it's agreed to do, then the whole thing kind of collapses. And I don't think you generally are seeing that with the political branches in the same way. So I think maybe I'll pause there and let Kristen take it up from there.
I completely agree with everything Oona said. You can absolutely feel free to speak for me in suggesting skepticism about these doctrines. So, Shalev, I agree. I think there are a lot of arguments to be made against the non-delegation doctrine and major questions doctrine in any of its many and ever-shifting incarnations. That's just we are not fighting that big battle in this paper. There's been a lot of ink spilled on that already. And I guess part of the reason I thought it was worthwhile to take on this project of a more focused one of challenging the court on the international agreements piece of this is because I'm truly not sure the court can be talked out of some version of this. I think we're going to continue to see, I think the action is going to be on the major questions doctrine. I think it's going to stick around, and I think challenges to any number of both domestic and international agreement related issues are going to keep coming. And I will say, I'm also, I think in thinking through how we frame this project, I'm not just worried about the Supreme Court. I'm worried about lower courts that have been more adventuresome in, finding standing in particular circumstances in their merits decisions. So these are things that could eventually be perhaps corrected at the Supreme Court level, but I think we begin to see some of the international damage, even if you have lower court judges who are being, who are sort of taking these doctrines and running with them. And then just a quick point on your question about international competence. I'm not okay with the president and Congress embarrassing us. I wish they would do that less. So I'd like to minimize embarrassment and chaos to the extent possible. But I do think there's something different about the courts doing that, because for the courts are sort of throwing out this chaos they are not the ones in a position to fix it, nor are they democratically accountable for the damage that they might be causing, right? So when the president or Congress does that, we at least have some tools of accountability to make them own those decisions. I think for the courts, they're a step removed. And I think, our example of Chadha and sort of the unintended consequences, there's a real danger that is a point where there's different institutional competence. I don't know that judges will necessarily, all judges, some judges certainly do well understand international issues, but not all judges do. And I think that could easily be underappreciated by judges considering these cases.
Jean, do you have a response?
Sure. Well, first, thank you. That's a great set of comments, and it ties to some of the continuing questions that I have about this paper. So to your first is Marshall over claiming. Yes, absolutely. Other people have said that, so I don't spend a lot of time on it. I actually think what he's really doing is just invoking a kind of international law principle here. That as a matter of international law, at this time, you have sort of one focal point of communication, and that's the executive branch. This question of who is the principal, does it really, if the president, Secretary of State is the organ of the president, we know who the principal is, but if the president's the organ of the nation, well, who decides what does it mean for the nation? So at a kind of narrow way, if you actually look at Marshall's speech, it goes on to really indicate that Congress is the principal, I think. It says Congress could give this all to someone else, Congress could change it, but until then, it's the president. So I actually think the speech itself tells you that Congress is the principal on this particular issue of extradition. But more broadly, one of the things that was interesting to me in my sort of looking at this word organ is there were almost no situations where you couldn't tell who the principal was or where there was no principal in a measurable way. There are almost no situations where it was the nation as much as it was something where if sometimes they say, the governor is the sole organ of the state in communicating with the federal government. And I don't think that meant the state governor. I think it means for the legislature, for the body. It's, again, I think you can infer it. So that's the point I can draw out. Now, does the president have to use the Secretary of State? How much is this really contributing to a kind of vision of bureaucracy? I have to think about that more. I'm not sure of the answers. There's certainly some usages that are more of the sole and only, which I think would go in that direction. And then there are some of the mere organ or an organ, which feel a lot less. But I think part of what it supports is that the idea is there's kind of a regular way of doing business, and that is not at the whim of the president so much. Now, how strongly or lightly it supports it, I have to do more to look at. Now, finally, the question on the methodology. I guess I would say my methodology is the debunking methodology, which is to say, if you were to ask me, how do we figure out how at this period of time, and this was the earliest period of time, they were thinking about the role of the president, the Secretary of State, and Congress, my methodology would not be just to find every use of the word organ and stare at it. But because the way that this word has come in, the methodology of Justice Sutherland, in essence, which has then gotten kind of baked into the practice, has been exactly that. I want to say, and this goes again to, I think, some of our conversations in the first panel about what's the methodology applied, partly to say if you take this approach seriously, you've got a lot of other organs you've got to think about too. And I have more work to do on both that early period and into the 20th century to see what the storyline is. I just haven't had time to run it all through all the places that I want to look at the moment. But really, I think this is useful largely as a kind of added debunking here rather than a kind of new theory of what's going on at the time of the framing in the 19th century in presidential power as it relates to Congress.
Great. Well, I feel like after I want to, as a former executive branch lawyer, I want to just defend executive branch lawyers for just a second. Andrew's saying OLC is President bats 1,000 in OLC, and I have to say, in my experience, we never told Congress to go away. Your points are very good ones, and I'm really it is actually, though, in my experience, which is anecdotal, but two administrations, there really is a much more. I just want everyone here to know there's actually a much more thorough. And, I don't think if you talk to the Department of Defense or the NSC at any point, they would say, OLC is saying, oh, sure, go for it. So anyway, that said, I thought your paper was so interesting and that the zombie quality, I thought was a really good point. And also, particularly the distinction between, mouthpiece and content, control over content. I just simply hadn't thought about it before. And I do think that that's still very relevant, even though, as you said, Curtis Wright, has been sort of shot down by the Supreme Court and isn't used as much, but that phrase is still out there. And before we...
Can I just...
Oh, sure.
I just want to put a pin. I don't think all OLCs are equal.
Yeah, that might be true.
In these matters, I feel much differently about how I think about OLC when I think of, I say Marty in it or someone else, and when I think of the OLCs in other eras where I really do read a Congress go away line as I read a lot of the letters that have been sent from, OLA actually, but channeling OLC over to Congress. So I want to suggest there may be heterogeneity in that and put you on the good end.
Okay, I'll take that. What do we have? Are we out of time, or do we have another 15 for questions? 3:45. Okay, so then one more just quick question before we go to questions from the audience. And this is just your reactions. In the first panel, we heard Marty, who's not normally I think of as a chill person, saying, "Oh, we don't really, have to worry." His view is we don't really have to worry about this, the major questions or a revitalized non-delegation doctrine in the foreign affairs. I hope I'm characterizing it correctly, and I just sort of wanted to get your all view on that. Do you worry about it?
I hope Marty's right. But I'm not going to bet on it.
Yeah. I think you guys made a good point, especially about district court judges. You can imagine a plaintiff who goes in and they're just like following on.
Right. Exactly. Yeah. It only takes one, and who knows? There's lots of these crazy cases that come out and they can do a lot of damage in the meantime.
Yeah. So I'll say I'm with Marty. I don't worry about it in the foreign affairs. I actually think that if you ask the Supreme Court care about international law, then I actually start to worry, because I see Medellin, I see Bond, both cases where the Supreme Court, against the view of the executive branch, said, nah, don't care so much about that international legal commitment the United States has made about making sure that we follow through on it. So I actually worry that international agreement exceptionalism, much as I personally agree with this, I think the need for flexibility with negotiating powers is crucial and important, but the tea leaves there, to me, are in tension with that.
There's very distinctive, that's a longer conversation to have, perhaps. There may be distinctive reasons Medellin and Bond came out the way that they did, and not necessarily be just exclusively about international agreements. Of course, you can point to, Dames and Moore, Curtis Wright. There's a lot of these cases that are out there where the courts are much more deferential. So, we have John here who can talk to us at length, I'm sure, about the facts behind Medellin. I think, and Bond was just kind of a crazy case, right? It was just like this extraordinarily weird situation that is kind of a purple giraffe. It's not the sort of thing you typically are likely to see. They gave them a chance to get out one particular boogeyman, which was really focused on Article 2 treaties, right? Not on executive agreements that they were trying to go after.
And the other thing that Bond and Medellin, just to jump in here for a second, have in common is the complicating factor and the complicating valence on the court about states' rights, right? So in a lot of the circumstances that I think we are most concerned about, you've got different poles here. You've got, antipathy to the administrative state. You've got deference to the executive on national security and foreign relations. And if you take out the states' rights piece of it, I think these cases might look quite different. It's a potential distinction of Bond and Medellin from other international agreement-related cases.
No, I would agree with that. Although I would say that in Bond, what the Supreme Court says is it's fine if this, we don't care what the treaty says. Maybe there is an international law obligation. But whatever the treaty says, we're going to interpret the implementing legislation a particular way, even if that's different from the treaty. So they are, in other words, driving a wedge between the treaty and the implementing legislation, which is really weird as a matter of statutory interpretation, but also to the extent that these treaties are relying on statutes, or these agreements and how they're interpreted. I feel that's a tricky factor.
I think this was a case where they got up to the edge of the precipice, they looked over and they're like, yeah, that's a little far, and they backed off, and this was the best way that they could kind of find to back off, and they came up with some slightly kind of convoluted reasoning for doing so, but yeah.
And this is basically, I think Oona and I both have a lot of affection for Justice O'Connor, but the genesis of both the federalism canon used in Bond and a lot of, Brown and Williamson is a major case in the major questions doctrine are both Justice O'Connor genesis, which is maybe not the best legacy. Yeah. So.
Great. Okay, so questions. Any questions from the audience? Yes.
I just have two quick questions for the panelists. First, for Oona and Kristen, are there any substantive differences between treaties and executive agreements? And for Jean, did General Milley commit treason?
What? Oh, bring it on.
Okay, on the treaties versus the executive agreements. Well, so under international law, all of them are treaties, but I assume you mean Article 2 treaties versus executive agreements. And that's a longer conversation. They're different in what ways, right? So different in terms of how they're made, absolutely, right? So Article 2 treaties are made with the advice and consent of 2/3 of the Senate. Executive agreements, different kinds are made in different ways, so ex-ante congressional executive agreements with prior congressional authorization, sole executive agreements under the president's own authority. So in that respect, they're different. In terms of what they can do, they are largely overlapping, though not entirely so. The treaty power is an independent power in the Constitution, so is not necessarily subject to the constraints of Article 1. Whereas congressional executive agreements are obviously subject to constraints of Article 1 because it's constrained by the scope of what the Congress can legislate, whereas sole executive agreements are constrained by the president's own constitutional authority. So the short answer is yes, but it depends on what dimension we're talking in, right? There's lots of different dimensions in which they are different, and there's some ways in which they're very similar. So a congressional executive agreement can be binding, create a binding international agreement that is, as a matter of international law, a treaty, right? So sometimes they're the same, sometimes they're very different, and it depends on kind of what we're talking about.
So your question to me feels a little outside the scope of my paper, but let me lean in here and say one of the reasons I'm thinking about this, question of the unitary executive is having faced the question of whether on the margins, I want or on the sort of with my risk hedging hat on, which is a pretty strong hat as a lawyer I want the charismatic president who blows through all the rules and all the structure of the administrative and so forth and does whatever they want and gets their thing done, or I like the more bureaucratic executive, which is slower and gets things done less well, but has a lot of rule of law and process constraints built into it. I land very firmly, very squarely in that one. Now, after January 6th, or on January 6th, we see this grave question about the chain of command, right, where there's a statement issued where he makes clear, General Milley makes clear that he's talking to the vice president, and to the heads of the, at that point, what is it, functional House of Representatives and the Senate, and indicates that to the extent that President Trump is trying to overthrow the election process, he's not going to go along. I am prepared at that very unpleasant moment to blame the president. And to say that public officials have an obligation, it's baked into our concept of public law to carry out their jobs in good faith. And where an official fails to do that, they put people who are under their command in a horrible and untenable position, such that as a matter of criminal law, and we see this in the law of command responsibility, sort of rules about you don't obey an illegal order as well, off the hook. So I might channel my sort of questions about where to put the blame in a different, with a different name there.
Before I go to the next question, I had notes all over to not forget the passwords, and I forgot the password before the Q&A. So the next password is agreements. And now we'll go on to...
Hi, I have a somewhat adjacent question that maybe comes a bit more from the international perspective, but it seems like over the
Adjacent to which question?
Sort of the overall idea of international agreements and the U.S. commitment to them. It seems like over the last few decades, the U.S. has been increasingly unwilling to commit to these international agreements, especially some of the larger ones, despite their theoretical universality, like the Convention on the Elimination of Discrimination Against Women, or the Rights of the Child, or even the Law of the Sea, despite the fact that we then take a lot of these values in as kind of custom. I was wondering if there is anything in this kind of domestic framework that could actually encourage us to maybe commit a bit more, and what's been holding us back when in the past we were willing to sign on to some of these like larger worldwide conventions.
Sure. Yeah, it's a good point. I mean, the short answer is that there's been so much ideological extremism within the Senate in particular that it's very hard to count to 67 these days. And it's just it's gotten to the point where it's just nearly impossible to get to 67, which is what's necessary for an Article 2 treaty, advice and consent. So when there is an Article 2 treaty that goes through, it's usually through unanimous consent. In order to get unanimous consent, it basically has to be kind of a cookie cutter, not very interesting, not very important thing, like the 127th extradition treaty that's identical to the other 126. So that's the short answer. I mean, that's the bigger question, and I think, one that is worth asking is, okay, if the Article 2 process is so broken, why don't we try to do it in another way? And there are other processes. So we've talked primarily about ex-ante congressional executive agreements, which are used for creating agreements through prior authorization from Congress. It wouldn't really work for the kinds of agreements you're talking about. There's another process, which is sometimes referred to as ex-post congressional executive agreements, often used for trade agreements. So where instead of the Article 2 process, what they do is Congress authorizes the agreement usually through its ordinary legislative process. You can have fast track, which limits the role of the committees and sort of requires things to get passed through more quickly, but basically through the ordinary legislative process. It means you have to get the House involved as well, so that's a hurdle, but you only have to count to 60 instead of to 67 in the Senate. And that difference is actually a pretty substantial one, but for some of these areas like the Convention on Elimination of Discrimination Against Women, there's an assumption that it needs to be done through the Article 2 process. I think that's worth questioning myself. For some of these agreements, same thing with Law of the Sea Convention, it's been tried through the Article 2 process. Once you try through, and same thing with the CEDAW, once you've tried doing it through the Article 2, a little harder to kind of shift gears and decide, okay, we're going to do it this other way to avoid those 7 senators we otherwise have to get. But that's the short answer, and it's unfortunate because it means the U.S. is kind of out of a lot of these really important agreements. The Law of the Sea Convention, I think, is a particularly important one that we are out of, and that really disables us in pretty substantial ways on some of the most important geopolitical issues facing us. But that's unfortunately kind of where we're stuck. I don't know if you want to add.
I'll just say John tried hard with that one.
Yeah.
So,
Yes, he
went
did.
out of committee unanimously once and didn't get through.
Yeah.
Thank you.
My understanding is that the case law has been settled at the Supreme Court level for some time on the issue of the retroactivity of its rulings. Is there stuff in the major questions cases in the last decade that deals with the retroactivity issue of the major questions doctrine? And whether there is or not, what would you like to say about that doctrine, the retroactivity doctrine, on the issue of past existing international agreements and commitments?
Sure, I can take that. So I think that there are different ways to think about retroactivity, and the Supreme Court has been more or less explicit about retroactivity in particular circumstances. But I think it's, for present purposes, the thing to understand about this is that the court is perfectly willing to apply the major questions doctrine, at least, to pre-existing delegations. So they are looking back, and when the case is presented to them, they're willing to upset sort of, it seems, long-standing statutory provisions. So we have no reason to believe that they would hold their fire for that reason with respect to existing international agreements. This is something that the court has done in other sort of foreign relations related issues over the years. They've done it with extraterritoriality. They've done it in particular circumstances. So the fact that we're talking about statutes or agreements that are already on the books does not seem like it would be any kind of a barrier to the court upsetting those existing authorities going forward.
I had a question for you, Professor Galbraith. First, thank you very much for this panel. I found it very interesting. I hope everyone else did as well. But in your research of this term sole organ, is there any use of it that distinguishes what aspect of international relations the sole organ is acting for? And the reason why I'm asking this is kind of thinking about what Professor Colonnesi mentioned in the first panel, where some of these delegations are for specific things where the Secretary of the State is the sole decision maker, like FTO designations, among other things. Thank you.
Yeah, it's a great question. So I guess I would say, yes, it doesn't seem to have, as I read the term, it has to do with the idea of being the spokesperson, and what the content is gets filled in by the things. So you see the organ used in respect to Congress when we're thinking about the declaring war power. Congress might be, the organ of the government that would communicate, not just make the decision there, but also separately communicate it. And you see this in, the Supreme Court. It sometimes talks about, the courts as organs in various ways. So I think there is some heterogeneity in how the term is used. And I have to dig a little more into that to get a more precise answer, but the basic answer is yes.
Okay, so before we close the panel, I want to give the final password, which is diplomacy. And everybody join me in thanking the panel.